It is July 6th of 2026, and this is the Court Gallery. Coming up, we begin in Judge Middleton's courtroom. First, he must decide the fate of a man's shovel after a tense standoff with a 10-year-old. Then he faces a young mother so dangerously intoxicated, she has no memory of the crime. The drama continues with Judge Elmore, whose defendant suddenly recalls his innocence right after taking a no-contest plea. Judge Stevens weighs mercy for a lengthy prison term for a man with 5 prior felonies. The problem? 5 previous convictions. Finally, things blow up in front of Judge Meyer when a routine hearing explodes into chaos as a defendant flies off the rails. All that and more starts right now.
All right, the first matter we're going to address is People versus Frank Leonard Butts. Mr. Butts was charged with 2 counts of resisting obstructing a police officer. 2 counts of assault and battery and 1 count of resisting obstructing a police officer. He entered a plea to attempted resisting obstructing a police officer and a charge of assault and battery. Mr. Bush and I are senior members of the practicing bar, and Mr. Butts has been around about as long as we have. And this is an interesting case, got some odd aspects to it. Mr. Bush has provided Abby Stoll and I with a letter from a neighbor of Mr. Butts regarding some of what's going on. Saw some pictures of some mean looking dogs. Mr. Bush, what would you like us to know here?
Frank is now 68 years of age. He's single, he has no minor children. He's retired and he was on disability, not in the best physical health, and he has a history of mental health. He's taking prescriptions for bipolar and depression and panic attacks. He has issues with his back, rotator cuff. He has a Michigan medical marijuana prescription for THC. He's already spent 4 days in jail in this case. It's too much of a simplification to say it was a misunderstanding. There was clearly a lot of tension that was going on in the neighborhood. I think Frank feels genuinely bad, sorry that he had no idea that the person behind the helmet was a child of that age. And that's one of the main reasons he accepted responsibility for the attempted for the assault, because he recognizes that he was put in a great deal of apprehension as a result of this. I think it's important is there was never any touching. In Frank's mind, he was defending the perimeters of his property that was repeatedly being driven over or being damaged by the vehicles from the victim and the victim's family. It's an event that I think everybody would like to do over again. I submit to the court that 2 days in jail is significant punishment for a 68-year-old man in this case when asked the court to sentence him to time served. Thank you.
Abby, what's your position here?
Your Honor, I would just let the court know that our office did try to get a hold of the victims. Unfortunately, we didn't hear back from them. I'd also add that I reviewed all of the body cam video and the full police report, and it concerns me that the defendant would become so upset and angry over something so minor. These kids were riding around on their four-wheelers. They turned just slightly into the defendant's yard, which is actually a part of the roadway. It's not the defendant's private property. There was no damage, but he threatened them with a shovel, which is entirely inappropriate. And then on the way to the jail, he was making comments. I'm not sure if you read the police report, Your Honor, but he was making comments about knowing Judge Middleton and that Judge Middleton would understand why he was so angry and would believe him and would let him go, which is also inappropriate. So I would just ask that the court take all of that into consideration, and I would leave sentencing to the court's discretion.
Yeah, he said he knows how to get away with crimes. They're scared of me, and I'm glad Judge Middleton would believe him and understand why he was annoyed by people riding four-wheelers and would let him go. He said he spent 25 years in prison, which isn't correct, and wasn't afraid to go to jail.
I'd like to explain myself if I could, Your Honor.
Yes, and then you were a pain in the neck when you got to the jail, and you were drunk. You were 0.150, which is not something we should ignore. You wouldn't have acted this way if you hadn't been drunk. I thought you weren't. I thought you quit drinking, but apparently not. Yes, Mr. Butts, what do you want me to know?
This whole thing it's already blown over. The neighbors, they moved, they got evicted.
So these neighbors with the four, they're gone?
They're gone. Well, they moved 2 blocks away,
Right.
but it's still further than what they were from me. They do continue to come down every once in a while, not late at night. They're not speeding or anything, but Mr. Hudson, yeah, he's a different story. He has come down a couple of different times, driven the motor up, kicking up a bunch of dust. I'm not saying that I'm trying to minimize anything. Like I told my attorney, I didn't know that the little 10-year-old boy was on the moped. They were taking turns riding the quad runner. And first it came across my yard, and then the next time it came down, somebody had a helmet on. And that was when I went out and stood beside my driveway with the shovel. And as soon as he turned around, I could tell he took the helmet off, and I seen it was a young boy. And so I am, because he was afraid, and I'm sorry for that. This has been going on for quite some time. The night of the 15th, or the night of the 16th, or the night of the 17th, take your pick. They were running out 2:30 in the morning.
Are you talking about June?
In April.
Oh, April. Okay.
April 17th, 2 couple of days before my arrest.
Okay.
Actually, it was about 3 or 4 days before my arrest. Every night, 9:30 to about 2:30 in the morning, they're running past my bedroom window with this 4Runner, and I'm trying to go to sleep. And it bothered me. After about the 4th night, I called the police on the 17th, and they came out there and they said, well, we'll go down and talk to him. And I said, I've talked to him. If you don't do something about it, I will. And he warned me, no, don't threaten him. Well, I didn't, and not at that time. And then a couple of days later, it was in the afternoon, and I seen him come down, and a couple of times they went by, and then the next time they come down, they went across my yard, and that was when I went out with a shovel. I didn't mean to resist the officer, but I did obstruct them a little bit, I guess, because they were trying to ask me for information, and I didn't want to talk to them. I called the police about these people. Other people in the neighborhood called the police about them, and nobody was able to do anything, so I decided to take it into my own hands and do what I knew I thought I could get away with without going off my property. Obviously, I was wrong, and I'm sorry for that.
All right, I'd hope maybe to hear from them. Some of this is on a public roadway, and you got 10-year-olds driving motorized vehicles without licenses and other stuff. And so to some extent, Yes?
I speak in his behalf.
You, Mr. Latchman? Are you Mr. Latchman?
No, I'm Mr. Cerny.
All right. You're here on whose behalf?
Frank.
All right. Yeah, I guess so. Mr. Cerny, come up to the podium if you would. And you've been here on some civil matters regarding your neighborhood out there,
Yes,
near Long Lake. State your name for the record, please, if you would.
I'm Ronald Cerny, 32226 Palmer Street, Colon, Michigan.
You had a nice piece of property there that you've improved and some other related properties.
Yes.
How close are you to where Mr. Butts is?
I'm one street behind, I'm right behind him.
All right, what would you like me to know?
Well, I even got some pictures here. I realize Frank's been in trouble before. We've addressed that before with you. This Mr. Hudson, I was on Zoom with you through Coldwater. We evicted him. You told me what I had to do that. And he ended up was a year behind on his payments. He took it to turn around. The place is so bad now, it has to be destroyed and put in a dumpster. It's uninhabitable. This Frank finally stood up for a lot of people out there because of this four-wheeler. I know he didn't do some things properly, but we were ready to take up a collection for him to come to court and hire a lawyer. But I got some pictures. I want to give you an illustration of what Frank has done.
All right, I don't.
Since he's been out there. I mean, he's contributed to the community. His home is meticulous. The neighbors all around him, he don't charge them. He keeps their places meticulous, that whole area, except for this Aaron Hudson's, which I have a picture of Frank's place. I have a picture of something Frank built this summer, a fence, not bought, hand built, that there's people who've gone around and take pictures of it. It's that great. Frank's a contributor to the community out there. He's not a hindrance and he tries to keep by himself. But in his case, I would have done the same thing. It's day after day, night after night, 1, 2 o'clock in the morning. No mufflers on this thing. And he continues to has to come by just yesterday, last night, come by and harass us again with that goofy thing.
Why don't we take the pictures? Thank you, Mr. Cerny, for being here. No one's here on behalf of them. One thing that I mentioned, he was drunk and he was very disrespectful to the cops. Well, that is a very nice fence. All right, thank you.
Thank
I
you.
think I've done work for your uncle too.
What's that?
I think I've done work for your uncle too,
Which uncle?
out on Clear Lake, out there by Clear Lake. His wife had a beauty shop.
Oh, that would be Pleasant Lake.
Yeah.
All right. Well, again, I don't like you dropping my name to the cops just because I've known you in the context of court, but I think I've always tried to treat you fairly. But
You have, sir.
it looks like you are doing a lot better. Your place looks great. I could see why you wouldn't like this. The other neighbors are also aggrieved by this, but it was a 10-year-old kid, and when you sometimes take the law into your own hands, it doesn't go well.
They think everybody's picking on them out there.
All right, well, I'm gonna give you 4 days, credit 4 days on the assault and battery case, concurrent with the attempted R&O. Let me ask again, I thought you had quit drinking.
I do occasionally, and I think that day I hadn't taken my medication.
So you're on
My
medication.
copay is $3, and I had ordered my medication, but because I couldn't.
Stop. You're 2 times drunk. You're taking all this different medication. You're not supposed to mix alcohol with it, which is why you were such a fool to the cops, because you were drunk.
Yes, sir.
You were mad and you were drunk. and the kid's 10 years old, you're lucky his dad didn't come over and shoot you or something. Don't take the law into your own hands, because it doesn't end up well for anybody.
Well, from here on out, I use my camera. I don't act, I just use my camera.
All right, that sounds safer. Apparently, they were annoying all the other neighbors as much as they were annoying you. But as I said, on the R&O charge, I'm gonna do the same thing. 4 days credit, 4 days. In 4 days, your life you're never gonna get back. Mr. Cerny did evict these people. There's a $75 fine, a $75 crime victims' rights fee, a $50 state minimum fee, and a $150 attorney fee. That comes out to $350. You posted a $400, $4,000 10% bond. I keep 10% of the 10%. The bond will cover your fines. You'll get a $10 refund. I don't want to hear any more about this. I don't want you chasing these kids or yelling at them.
It's over.
All right. And I'm glad it's over. All right.
Thank you, Judge.
All right, thank you.
Oh,
Let's, you go out to the counter and you'll get a little bit of your money back. But
okay, could you, contact the sheriff's department and turn my shovel back over to me?
No. You get a new shovel. It's threatening this 10-year-old kid with a shovel. That's part of your sanction. All right, you're good to go. All right, Abby's taking her leave. This next case is an ordinance case. Tiffany Tincher. This one, I don't know what to do. Mr. Huff has inherited this. Here, a screening report for us. This Tincher was charged with operating with a while intoxicated. Prosecutor agreed not to charge high blood alcohol level. She was very intoxicated, now out of control. And I don't know what to do here. Mr. Bush, could you help me here? What are your thoughts?
Well, the one thing she wanted the court to know is she was very, very intoxicated. But it's her belief and understanding that she did consume alcohol at the liquor store in the hour gap between when she got there and the police arrived. I'm not making the argument that she was sober when she got there. That's not what we're saying. There was a lot of alcohol in her system, but it's her belief that some of it was consumed after she arrived at the liquor store. Talking to her, she realizes that she needs to make a major change right now. She's extremely nervous today, which is probably good. She's really concerned about what's going to happen. She is a single mother. She has a lot going on. She's very young. Regardless of when it happened, we always have the guideline, if your blood alcohol level is greater than your age, it's a major red flag. And her alcohol level was way above her age. I'm glad that she's already involved with the pivotal services right now. She seems to be embracing that from talking to her. She's going to have to do a lot to make the changes, but I would ask the court to implement and follow the recommendation.
Tiffany, what were you drinking?
I was drinking MXDs and I think it's a vodka. I kind of can't remember like how much I drank, but
What are MXDs?
it's like a mixed drink. They're pretty strong. It's 12%. And then the 99 shots, just like little shots or double shots. I think it's vodka.
Well, you're killing the pain. Matt, what's your thought here?
This is a very difficult case. Ms. Tincher's young, obviously. She's got some issues going on. Well, I only have an hour to meet with somebody prior to court. There's enough going on here that I can't get everything in. I will say that I submitted this recommendation last week, and then I checked this morning. We had received the substance abuse assessment that I requested from Pivotal over the weekend, and then I added that to the file. After reviewing it,
Oh, I didn't see it.
I added it this morning. So
I'm not sure it's in my file.
it should be. It's 28 pages, so I can give you a synopsis of it, but it's very helpful because there's a lot of insight in there, a lot of things that I wasn't able to get to just based on, the logistics.
There, it just popped up.
Yeah, she's fully embracing treatment. It's co-occurring. She's got some stuff. I think perhaps the most helpful extraction out of that assessment is that she's ready to unload all of her stuff. She's ready to deal with some things that she's been self-medicating for. She's admitting this, which is a good sign, especially at her age, that she wants a better future for herself and her child. The case facts are not good. As laid out in the report, there's a dog involved. She's so intoxicated that the convenience store attendant has to call the police and try to prevent her from getting in the vehicle. There's some resisting element as well in this. I'm mentioning purely for the fact of departing from the presumption of fines and costs. I think she was so intoxicated, she doesn't really remember what was going on that day. That's not an excuse for her behavior by any means, but the refusal, in my mind, there's a couple of different ways that you can factor in refusal for a chemical test, right? She was beyond, I think, the ability to even submit to a chemical test. However, the statute is what it is, and she was marked as a refusal, so she'll have to deal with some of those ramifications going forward.
You're gonna lose your driver's license. Is that ramification?
Yeah, I know that.
Given all that I've talked about here this morning, and what I learned from that substance abuse assessment from Pivotal, I had initially made a recommendation for a scheduled day in jail. I think community work service can have the same impact in this, so I'm somewhat adopting on the fly a recommendation I would put in front of the court. I think 24 hours community work service instead of scheduling a day in jail would be appropriate, given her age and lack of criminal history. And then obviously I think that there should be some deferred jail to return back to if Ms. Tincher's not going to take this serious. I think she is, though. I also made a recommendation for the victim impact panel for her to comply with treatment, fines and costs, and a 12-month probation.
Ms. Tincher, anything you'd like to say to me?
Yeah, I just want you to know that I am very embarrassed. I made a really big mistake, and I'm sorry to you, myself, and the officers for the way that I acted that night. And I do want you to know that if I wasn't drunk that night, I wouldn't have acted like that. And that's not me at all. And I don't want to be portrayed as that. Like, I don't want this to paint a picture for me, because that's not me at all. And I don't want to live this life. I don't want to, this is scary for me. I can't. I don't want to be taken from my daughter again. I promise you, if you give me the chance to prove myself to you, you will not be disappointed. And I am sorry once again, and I'm embarrassed.
What's your relationship with your child's father?
It's kind of rocky. Right now, we're like kind of on and off, I guess. We kind of fight a lot. We're kind of toxic.
Does he see the child?
Yeah,
Does he pay any support?
yeah, he told me I didn't have to work, and he pays everything just so I could be home with her.
So do you two live together?
No, he stays the night sometimes with her so he can see her.
But he's paying all your overhead?
Yes, he wanted to do that. He offered to do that because I moved all the way from my home to Three Rivers to be with him.
Yeah, you're from up north.
I'm from Niles, Michigan.
Oh, Niles, sorry.
So that was a really big change for me. And I guess he kind of just wanted to help out, I guess, and let me be with her while he works.
What kind of work have you done?
I've done a lot of CNA. I've worked at Walmart. I've been a housekeeper before. I've worked at Amazon. I delivered for them. So before I got pregnant, I always had a job.
Do you remember what upset you this particular day?
Well, it was ongoing. My grandma had just passed. I watched her pass away. She was really bad. We had got into it, and my daughter's never been taken from me, and he took her. So I guess I didn't know how to deal with that, I guess. And then I found out something medically as well prior to this day. So it was just kind of a lot built up, and I wasn't really taking it serious enough. So I guess I just kind of
Well, you were certainly self-medicating. I'm surprised that you could contain that much alcohol. Did you
I
get,
blacked out, Your Honor.
well, did you get sick?
I don't know. I don't remember anything.
Well, they have to take you to the hospital at 3-2. They did take you to the hospital, but it was not good.
Yeah, I was very drunk. I heard about that, but I don't remember any of that. And I'm embarrassed, honestly.
And Mr. Bush's representation that you drank some more at the liquor store, I think probably is.
Yes, that's why I went there. And
But I think there's sufficient evidence that you were over the legal limit when you got from Javier to Paul's Pantry. But you were difficult for the officers and the hospital staff, and it wasn't good. I am gonna do a 12-month probation.
I'm sorry, Your Honor.
I'm gonna do a 12-month probation. I'm gonna do the original recommendation. 10 days jail. Credit 1. Leaving 9 days to serve. Of the 10 days, 8 are deferred. You got a day to do for all the aggravation for the police, the hospital staff, the people at the store. This was scary for them. I'm gonna make the fine 0. It's normally $300, right? Now you don't have any income, but this is expensive. $75 crime victims' rights fee, $50 state minimum fee, $100 screening fee, $150 attorney fee, $480 probation oversight fee. And they didn't do a police reimbursement.
There wasn't one contained in the police report that I obtained from
Just
the
real
Rivers.
good at that lately. And the victim impact panel is $32. Let's add that up. 125 plus 100 plus 480 plus 32 is 737. When did you last have something to drink?
That night, Your Honor.
All right, so no alcohol since.
I haven't drank since that night.
Very good. Very good. You got a 2-year-old daughter that needs you.
I know.
No drugs, no alcohol. Test as directed. You're gonna lose your driver's license, which might not be fair in light of the fact that you don't have a clear recollection of what happened. But as Matt put it, this whole thing went into effect and you have to deal with the consequence of it. Now, there's Kleenexes right there. You're connected with Pivotal, which is the best thing in the whole thing. You've got lots of baggage that you're carrying that you ought to be able to put some of it down. When I see a young woman your age with this high of a blood alcohol level, I know there's childhood trauma. And you're apparently ready to deal with that at Pivotal. And that's more important than any other component of this. Um, and it seems to me that you're sincerely plugged into it. I don't think you're just going through the motions. This is an opportunity for you to address this and make things better. The last lady I just saw, she's older than you are. She was half as much alcohol, but same thing. She was embarrassed. Her car got towed, your car got towed. That's all expensive. She's gonna keep her license. You're gonna lose yours. And that's hard when you're a young mother and you gotta drive your daughter to appointments and you're gonna have to go through struggles to get it back. But I want you to stay sincerely plugged into Pivotal and deal with the underlying issues that set this all in motion. I didn't do a probation form here, but I want you to go with Mr. Huff. He will meet with you and get you plugged into this probation. You got a day in jail to do. That's part of the additional consequences.
I went to jail.
You're gonna do one more. 1 day sober, 1 day drunk for the Tasmanian devil behavior. All right, you can go with the court officer.
We are on the record in BU 2022 CR 302, State of Kansas versus Patrick Albert McTaggart. Please announce appearances.
May it please the court, Cole Storr for the state.
Your Honor, Darren Patterson appearing on behalf of Patrick McTaggart. Mr. McTaggart does appear personally via Zoom audio visual from Butler County Detention Center. Judge would announce at this time, pursuant to plea negotiations, Mr. McTaggart will be entering a plea of no contest to the sole count cruelty to animals.
And Mr. McTaggart, this case has had a lot of hearings since October 24th of 22. But are you to the point now where you do want to enter a no contest plea?
Yes, ma'am.
By pleading no contest to cruelty to animals, you're not wanting to admit the charge, but you don't want to deny it and set it for trial either?
Correct.
Is that correct?
Yes, ma'am.
It is alleged that on July 19th of 2022, you did unlawfully and knowingly have physical custody of an animal, to wit 3 horses, Bert, a Palomino Mustang, Ernie, a Palomino Mustang, and Jenny, a bay mare quarter horse, and you failed to provide such food, potable water, protection from the elements, opportunity for exercise, and other care as needed for the health or well-being of such kind of animals. This is a Class A non-person misdemeanor. Now, even though you're not admitting this charge, by taking a no contest plea, you still will most likely be found guilty. Do you understand that?
Yes, ma'am.
And you are giving up your right to a trial. Do you understand that?
Yes, ma'am.
Is anyone making you enter this no contest plea today?
Is in accordance with the plea agreement.
So other than to take advantage of a plea agreement, you're not feeling anyone's making you do this?
No, ma'am.
And what is the nature of the plea agreement?
Your Honor, it would be for a 6-month controlling sentence with 6 months probation, standard conditions, no livestock, court costs for the court to determine attorney fees and restitution to Butler County for $2,881.50.
$2,881 and what change?
50 cents.
All right. All right, so those are the terms that you understand your plea agreement to include, sir?
Yes, ma'am.
Yes, Judge. Oh, sorry.
Okay, no, that's all right. Okay. All right, I will find that you know what you're doing in entering this plea and that you're doing it freely and voluntarily. Mr. Store, do you have a factual basis to support this charge and this plea?
Ooh, good question.
And Judge, for purposes of the factual basis, we would stipulate to the affidavit filed in the case.
All right, there was filed on August 15th of 2022, an affidavit to support request for prosecution that was prepared by affiant E. Robert Latimer, deputy with the Butler County Sheriff. And would you offer that as a factual basis as well, Mr. Storr?
I would, Your Honor.
All right, I will review that quickly. July 22nd, 2022, there was a dispatch to emergency communications of a horse that had gotten trapped underneath a fence and had died. The officer went to the residence that appeared to have been vacant for some time. Palomino breed Mustang Bert was deceased under the corral fence. Holes dug into the dirt beneath Bert's hooves. Hair and skin from his neck snagged on a barbed wire fence, head and neck, and so forth. Rib cage caught on the lowest board, trapping him. He appeared to have struggled to free himself, using both his head and hooves. No food in the corral, very small amount of water in the corral. Temperatures the past weeks have been around 100 or higher. The metal stock tank had green with brown and white algae and debris, no fresh water. Strong smell of putrefaction and decomposition. Maggots both inside and outside the horse's body. And so forth. Okay. And they looked for the other two horses. Neighbors hadn't seen anyone caring for the horses in a while. The question to Natalie McTaggart. And apparently the parties, Mr. Petz was supposed to be the one taking care of the horses, according to his wife or ex-wife. All right, I find that there is a factual basis to support the charge and the no contest plea, and I do find the defendant guilty of the charge of cruelty to animals. A Class A non-person misdemeanor. I talked about Bert, but Ernie was also involved in another horse that was covered in the affidavit. Okay, I will follow the plea agreement, Mr. McTaggart, and there will not be a fine, but you are ordered to pay restitution to the Butler County Sheriff's Office of $2,881.50. Where do you work when you're not in custody, sir?
At this point, I don't have a job anymore because I'm over here. So
Okay.
I'm retired military. I have a retirement and that's it until I
Okay.
get back home and find a job.
All right, and you've been in custody since how long
Since April?
of this year?
Yes.
All right, I'm going to waive your court-appointed attorney fees, but you do have to pay, and your fines, but you do have to pay that restitution, court costs, and supervision fee. Your sentence, I will go with your plea agreement with 6 months, but frankly, the facts behind that charge make me want to go with a year, but your sentence will be 6 months. Well, how much time have you served?
3 months. I've been here since April.
And Judge, just for the court's information, this is a case where he spent substantial time in Missouri jail also before being transferred here to Butler County. He is currently on probation in Missouri, and that's where he does plan to reside.
What's he, on correction, what's he being supervised in Missouri for? What charge?
I don't have that information, Judge.
I'm in a recovery court program. I get a DUI.
Mhm. Well, I'm thinking maximum 12 months. Plea agreement is 6 months. I'm going to give you 9 months, 9-month sentence, which. And how much probation time do you have left in Missouri?
It's an 18-month program.
I'll give you a 12-month probation reporting, and that can be transferred to the other state if they need to. Did you get the DUI first or this charge?
Discharge.
Okay.
I got the DUIs in July of 2024.
Okay. While you're on bond in this case. All right. All standard conditions will apply. Contact the probation department here as soon as you get out of custody. You are entitled to credit for time served on this case, not the Missouri case, but on this case. And we're to have no livestock, animals, anything of that sort as a condition of probation. Comply with the other probation you're on. Anything else, Mr. Storr, that we need to do to order?
I don't believe so.
All right, Mr. Patterson, anything further?
Nothing further, Judge.
All right, Mr. McTaggart, anything further?
No, ma'am.
All right, then you are excused on this case and will be in recess. You're returned to the custody of the sheriff.
All right. Our next case is People of the State of Michigan versus Joshua Meekoff. All right, so this is case number 26-3659FH. Is this Mr. Meekoff?
It is.
Yeah, sit next to him. All right, thank you. He doesn't bite.
Yeah.
Hard. All right, appearances. Mr. Dillon, did I get yours already?
Not yet, you're all right. Thank you, David and Helen, on behalf of the people, Your Honor. Thank you.
Robert Hartzell for Mr. Meekoff, who joined me on the left, Your Honor.
Right, you may be seated. All right, we're here today for sentencing in this case. It involves conviction for 2 and operating while intoxicated is a third offense, and possession of a firearm while under the influence. It was resolved with a couple pleas of no contest back on May 8th. One moment. Yeah, there we go. I knew I had something else. So review these earlier. All right, so also before we get to the pre-sentence investigation report, this court received last, I think it was Wednesday or Tuesday, a Catholic Human Services report on Mr. Meekoff, talking about or giving me an alcohol or substance use assessment. I read through that, made some notes and things like that. So I covered that last week, and also received by my office on that same day was a mitigation report for Mr. Meekoff. And normally I make notes, so give me just a moment. Oh yeah, the Sarah Lee Bakery. All right, now I remember. And then attached to that were several letters. We have one from Dr. Deere, who is at the Lakeshore Community Counseling Center, talking about the progress there. And there were some other statements or letters here that I received. And it looks like he's done a pretty consistent job here with attending AA classes. All right, let's turn right back here to the pre-sentence investigation report. Mr. Denham, do people have any amendments, corrections, or objections to make to the contents of that report?
Thank you, Your Honor. I have reviewed that report thoroughly, and I have no proposed corrections, additions, or deletions.
Okay, thank you. Mr. Hartel, same question, sir.
Yes, Your Honor. We asked the court to consider on CFJ 145 under the term of probation, term 4.20, amending that just to no firearms. I do believe it would be appropriate. That way my client could still go bow hunting, things of that nature. We're not sure how much probation the court's going to give him, but don't believe there are any allegations in the report of any bows being misplaced, anything. I do realize there were other issues the court may take issue with.
Which you said 4.20?
I believe
Yep.
that's the condition where it mentions no weapons, Your Honor.
Yep, all right.
I know the court sometimes has given that grace. I'd ask the court to consider it in this situation. Thank you.
Thank you. That's really more for or allocution and mitigation. Mr. Denoughton, do you have any comment on that?
On that particular condition, I would simply leave it to discretion.
Copy that. Thank you. All right. Let me take a quick look. Anything else, Mr. Martell, as to the contents of the report?
No, Your Honor.
All right. Thank you. I'll just note here, I did go through obviously the CFJ 384 section. There were a couple of charges or cases for which he had some dismissals. Clearly, the court does not take those into consideration. And I don't think I had any other corrections here to make. All right, allocution. I'll start with Mr. Denham. Sir?
Thank you. First, the people, I guess I'll start out positive. I'm not aware of bond violations, any bond violations. So give credit to the defendant for that. I think that he's been performing well on bond. However, the defendant did receive a significant benefit of the plea agreement. We did dismiss the felony firearm count. I support the recommendation. The incident itself involved allegations, being on the lookout call. Allegedly, the defendant was all over the roadway. Ultimately, he was found at the local Wesco. He was somewhat non-compliant. When the blood draw was done, which was approximately 2 hours after the incident, so a significant period of time had elapsed, he still had a blood alcohol content of 0.239, which is, as the court is aware, about 3 times over the legal limit. So significant.
I think we need to let him finish out if you know. Thank you.
Hold on just a minute. Go ahead, Mr. Denham.
Okay, so significantly over the legal limit. There was a loaded gun in the vehicle. There were vodka bottles, at least 2. The PSI report notes that there's been a series of drinking and driving convictions in a relatively short span in the last few years. The defendant, I guess, reached my radar and of some concern on the 2024 incident, the failure to report an accident. That involved the defendant running into the backside of a manure spreader that was going 33 miles per hour at the time. He went into the ditch, went through the windshield. Witnesses indicated that blood was coming from his nose, and he was picked up from someone. So that raised some concerns for the people, given that scenario. He was not at the scene, so he was not charged. I'll leave it at the leaving the scene of an accident. But certainly that raised some additional concerns separate and apart from the OWI convictions. I do support the recommendation, Your Honor. I would respectfully request the court follow the recommendation of the probation department.
Mr. Hartel, did we miss something? Did there need to be a change?
Not that needs to be changed, Your Honor. My client may or may not wish to make a statement after my elocution. That's what he was informed.
Oh, okay, no problem. All right, thank you. Mr. Hartel, floor is yours.
Thank you, Your Honor. We also recognize that my client received a significant benefit from this plea. We realized there was an absolute minimum sentence as it was charged that would have sent him to prison. We're very glad that's not happening. He's cognizant of that fact here today. He is employed, as the court did note, at Sara Lee Factory. He reminded me earlier this morning, his shift is from 2 a.m. to 2 p.m. Quite the fun shift. I've done a few of those myself at different locations, or things close to them, maybe graveyard shift is my point. We would ask the court to fashion a sentence where he could maintain that employment and do the jail sentence on the weekends. We realize there's a minimum 30 days here, and the court can go above that. But I know sometimes the court does allow, with its grace, to allow my clients to do 48-hour chunks on the weekends. And even though I've informed him you most likely would want a GPS tether on him as you've done in the past, he would be willing to comply with that. He very much so wants to keep this job. He's informed me he has the support of his coworkers. He wants to continue to show them that he can be a good colleague, have his job so that he has good support structure when he gets done with the term of probation, that we don't doubt Your Honor will give him probation as well. He also continues to have the support of his family. I know some friends and family wrote letters. Others I'm informed, still support him, but just didn't quite get the pen to the paper, but are definitely still there. They may or may not be watching right now, in fact. I would also ask the court to consider allowing him a week before starting any jail sentence so that he could tell his employer exactly what's going on. He was honest with them, he tells me, but because he didn't know exactly what the sentence would be, he obviously wasn't able to communicate that. So if the court give him a little bit of grace before the first day in jail, we'd appreciate that as well. As was noted a moment ago, he may or may not wish to make a statement. That's at his discretion. I've given him my advice on which things may or may not be the best to say. I realize this was a no contest, so I won't overly allocute. I know the court has to take everything in the report as accurate, but because it was more for lack of recollection than civil liability, if he suddenly had better recollection, I just ask the court to factor that in. Thank you.
All right. Mr. Minkoff, you have the right to make a statement if you so choose.
I guess all I've got to say is that night was 35-mile-an-hour winds. It was windy. I hadn't drank until I was at the parking lot waiting for my ride to pick me up. Vehicle was off, and the person picking me up did speak to the cop on the phone when he approached me, I was on the phone with them. I guess that's about it. Again, if I could somehow maintain my job, that'd be great. Or if not, I understand.
Okay, I'm sorry, keep going.
I guess a week or so I could get my house arranged. That way I could let my landlord know that I'd be leaving the property or whatever.
Whose vehicle was this?
Well, it was my mother's.
How'd you get it?
I was working on it.
Okay. How do you get to and from work?
I get picked up by carpool. That my mom will take me to work.
How is that you remember this now and you didn't remember anything last time I took the plea 2 months ago?
I guess I didn't really quite understand everything.
What do you mean you didn't understand everything?
As in like the no contest or whatnot.
I explained it to you. I told you couldn't challenge what was in the report.
Right.
How was that not clear?
I guess I just wasn't. I mean,
you weren't being honest with yourself or with the court, because I'm pretty clear when I do a no contest plea.
Right.
And you told me you couldn't remember, which means if you try to tell me you remember stuff, I think you're lying. So I don't know. There is no better way to explain it than I do. I'm pretty sure I'm not patting myself on the back, but I say you cannot challenge what is said in here. And so I don't care if it was windy. You were obliteratedly drunk, swerving, putting people in danger. Whatever you've been telling yourself prior to sitting there in that chair today is wrong. Your hopes are not going to be met. You will be leaving through that door in about 4 minutes. You are not going to go to work and say, and give you another week. I don't know what the heck you've been doing in the last 2 months if you didn't tell them that that was a possibility. That does not matter. You are 31 and you have 3 drinking and drivings within 6 years. And in this instance, you were all over the road enough that people called police. You were driving when you could not drive a car. You were unlawful for you to drive a car. And it was unlawful for you to possess a firearm. Was that, am I right?
Loaded firearm, yeah.
Yeah. No. You're not gonna let you go hunting. You can't possess a firearm. You can't possess a loaded firearm. And you were drunk with the blood alcohol level that would put most people in bed for a couple days, passed out. Oh no. I really hope what you told me was the truth. And if your mom's out there watching and she says, thinks to herself and she goes, well, I kind of let him have it, borrow it. It's her fault then that you got it. If she didn't, then that's not her fault. It's only your fault. So I don't want to be insulting to your mother, but I'll tell you, if somebody else was letting you drive their car, they were wrong. Had you killed somebody, it would have been on them too. Yeah. No. I appreciate you've been going to AA. That's great. Because you need it. Now I'm also looking here, and there's some issues here about, depression and anxiety. I don't see any medications of treatment because apparently you are treating everything with alcoholism. And you began using at a young age, age 17, 3 to 4 times a week in the last 13, 14 years. Wow. You set yourself up for failure.
Yes, Your Honor.
So, and I'll tell you why I talked about credibility. And that's what I jumped on right away when you started telling me about what you remember and then telling me I didn't do a good enough job explaining it to you. Well, you had a 3/4 empty bottle of Smirnoff in the car. But actually, there are 2 bottles. You lied to the cops about what you had been drinking. Failed 3 tests that were given to you. So again, 31 years of age, and your criminal history began about 15 years ago. Unlawful driving away of a motor vehicle and malicious damage of property. You were given a chance. Then you have this fail to stop at an auto accident. Then you have in 2019 an open intoxicant vehicle and violence charge, although there's only an open intox for a conviction. Then in 2020, sure enough, open intox and drinking and driving. 2022, open intox and drinking and driving. And then 2023, driving a vehicle while your license was suspended, denied, or revoked. I'm not going to ask, and I don't want you to answer because it ain't going to go well. Boy, I would like to know whose car that was. And then in 2023, which was while you were on probation for the last one, you picked up another driving license suspended, which means deception. You're going to do whatever you want when you think no one is looking. And then 2024, oh my gosh. Failed to report an accident and driving license is suspended, denied, or revoked. Now that charge was dismissed, but if you fail to report an accident, it doesn't take much. It's a logical conclusion that you were driving while your license was suspended. And I would love to know whose vehicle you were driving those times. Who's ever allowing you to drive their vehicles? It's too bad on them. And now here you are in about a year and you've got felony firearm, R&O, which I know those were dismissed, the possession while drunk, operating while your license is suspended and not revoked, which I know that was dismissed, but I can tell if you were drinking and driving, you were driving when your license was suspended. So I've got deception, alcohol, and violence wrapped all under one here. So, yeah, it might be a good employee, but boy, I would never let you walk into my place of business or work without giving you a breath test every single time. So I appreciate that you're getting the help here, and that's great. And I'm going to help. So at the age of 31, you realize your days of consuming alcohol are without a doubt done. Because if you do it again and you get caught, your only next place to go is prison. And I would have no problem sending a 4th drinking and driver to prison.
Yes, Your Honor.
The court sentences the defendant as follows: 36 months of probation. You have the right to be considered for early release from that probation at halftime if you are successful with the terms and conditions of that probation. The court adopts every single one of the terms and conditions that are listed in CFJ 145, pages 2 and 3. And I find that they're well suited for rehabilitative purposes. In this particular file, The court sentences the defendant to 12 months in the Missaukee County Jail, and he receives 3 days of credit. Court assesses a $68 state minimum fee for the felony, and there were two, and the other is a $50 state minimum fee for the misdemeanor, $130 crime victims' right fund fee, a $300 court cost, a $500 fine, and a $300 attorney fee for all the processing of this case from beginning to end. DNA fee was already available, apparently. Supervision fees are $30 a month or $60 a month if there's any electronic monitoring. So again, that's actually listed as 365 days.
Okay.
All right. Have I missed anything, Mr. Blazak?
I just wasn't sure if you were done with the second.
Oh, second, thank you. 93, I'm just going to go 90 days of jail with 33 days of credit. Those two sentences run concurrently with one another. All right. Thank you. Anything else, Mr. Blazak?
No, thank you.
Mr. Denham?
Nothing further, Your Honor.
Okay, Mr. Hartel is going to bring you 2 copies of one document. You're going to place your initials on one copy. Doing so neither elects nor waives any rights. Based upon the plea, any appeal done in this case will be by filing an application for leave to appeal and not an automatic claim of appeal by right. Furthermore, if you wish to have the court appoint an attorney to assist you in an appeal, you may complete the bottom half of that document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. The number one thing you did wrong, the number one thing you tried to do today was try to tell me, oh yeah, now I remember, and I wasn't told well enough what was going on. I didn't understand. I don't believe you. Don't talk. You're going to make it worse. Just put your initial on that one page. The sentence is well within the guidelines. This is a straddle cell. The court could easily send the defendant to prison. And you're going to note one thing. Had I sent you to prison, you could have gotten boot camp. You probably could be out a lot faster than you will be when you're going that way. Thank you, Mr. Hartel. Blaming it on the wind.
My client has asked me to ask the court. I know the court.
No. Going to jail. It's not on weekends. You're going to jail. Blaming it on the wind, that was a bad choice. Thank you. All right. Oh.
James Mendoza, correct? Okay, any James Mendoza, please? Thank you. This was he's already entered his plea, right?
Yes, sir.
Okay. So plead guilty on March 9th. Yes, ma'am. All right, this 24 CR 1769 is now called the state of Texas versus James Philip Mendoza. That is you. Yes, sir. With Ms. Pelosi, your attorney, the state's attorney, Mr. Ham's present. Earlier, you entered a plea of guilty to the 3rd-degree felony of evading arrest or detention, and the state's enhanced. The defendant pleaded true to the 3rd paragraph, which states that the defendant committed the felony illegal possession of a controlled substance with intent to deliver a 1st-degree felony, and was finally convicted on October 3rd, 2017 in the 364th District Court of Lubbock County, Texas, which was prior to the commission of this offense you're here for, evading arrest or detention with a motor vehicle, which occurred on or about June 23rd, 2024. And he only pleaded true to one allegation, right?
Correct, Judge.
So-
Abandoned the other.
One prior conviction.
Yes.
So this is a 3rd-degree felony enhanced as though it were 2nd-degree felony punishment.
Yes, sir.
So you're looking at no less than 2 nor more than 20 years confinement in prison.
He pled to a 15-year cap, Your Honor, and
15 years. And
And then the,
So it's no less than 2 nor more than 15.
Yes, sir.
Is what we're looking at. And also he can get probation in front of me, but he can't get it in front of a jury.
yes, sir.
Correct. Right. All right, again, cap of 15. So you're looking at 2 options here, no less than 2 nor more than 15 years confinement in prison. And or probation, where you could be sentenced up to 10 years in prison, and that could be suspended and you could be placed on probation. All right, you may go first. And
Thank you, Your Honor. Do we need to swear him in first?
is he going to testify?
Yes, sir.
Okay, raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and to nothing but the truth, so help you God?
Yes, Your Honor.
Lower your hand. Go ahead. Thank you.
Your Honor, first I would like to call your attention to the precinct's investigation report.
Which part?
Well, there are several issues. And I wouldn't necessarily call them issues, but things that need clarification or things that appear to be missing that I think need to be addressed.
Okay.
Page number 4, very top portion where it goes over some factors in his childhood that Mr. Mendoza experienced while growing up. There was a bullet point that was blank, as though there was something that was meant to be there, which is one of the most important factors, I believe, that triggered Mr. Mendoza's post-traumatic stress disorder that's mentioned in his medical records from Spindletop. And just, I'm not sure, Your Honor, since this does involve sensitive medical information, if this is something that needs to be broadcasted. I don't know if that's something that we might want to consider before we
I
get
don't know.
into the
I
medical
don't know.
record.
I've never muted them before.
You know, okay. Well, with authorization from Mr. Mendoza, I believe we can proceed live or on YouTube. Going back to the bullet point that appears to have missing information. Mr. Mendoza, as a juvenile, experienced the murder of his sister. This is
By whom?
by I will.
Her husband.
It's yes.
Do you need the name?
No, I just need the relationship.
It was her husband at the time.
What happened to that in that case?
They
I'm talking about the disposition. The husband was convicted?
Yes.
And sentenced to what? Do you remember?
Life with the possibility.
And Your Honor, that being experienced by Mr. Mendoza as a child.
How old were you?
I was 22, sir.
I'm sorry, a young adult. Anyway, he was young.
How old was she?
She was 20.
Your younger sister?
Yes.
How many siblings do you have?
One other older sister, and then my mom adopted my daughter, or my sister's daughter, and another little boy after my father passed away.
Okay.
Sure.
That incident being witnessed by Mr. Mendoza triggered severe depression. He was diagnosed with major depressive disorder in 2001.
When was this? When did this event occur?
In 2005.
And he was.
And schizophrenia in 2023, and as early as March of 24, 3 months prior to the alleged offense that he's already pled guilty to. I don't want to say alleged, but the offense that he pled guilty to. He was also diagnosed with the post-traumatic stress disorder. I would also like to point out in his medical records from Spindletop, and right in the beginning, and the date of diagnosis, which is March 8th of 2024, his primary diagnosis at this time, which again is 3 months prior to the offense in June of 24, was schizoaffective disorder, bipolar type, post-traumatic stress disorder. He was prescribed 2 different medications, and this again was 3 months prior to this offense date. On March 14th of 23, he was prescribed sertraline and Vraylar. March 8th of 2024, he was on Vraylar, but then he was given sertraline. Then they discontinued that, and just days later put him back on Vraylar and sertraline. And the medication withdrawal and the change in his body and psychosis because of these medications being changed caused him extreme panic attacks, unusual thought patterns. He mentioned this.
When?
This was 3 months prior to the offense.
To this event.
Yes, sir.
Go ahead.
He brought this to the attention of the person that had prescribed him, to the doctor that prescribed the medication, and so that, you know, he was having unusual thought patterns. And I would also like to bring to the court's attention in the medical records that just 6 months after this event occurred, he was seen in December of 2024. And there's like a category of issues that they assign a number to based on the level of the severity. Suspiciousness being 1, moderate. They gave it a score of 4. Unusual thought content, 4, moderate. Hallucinations, 4, moderate. And at the time that this event occurred, as stated in the pre-sentence investigation report, Mr. Mendoza was experiencing a psychotic episode wherein he strongly believed, even though irrationally, but still he believed wholeheartedly that a female friend of his was being sexually assaulted. And so in his mind, he was off to save her. He had previously had an interaction with the police wherein he was injured. They shattered his window. It was in a separate offense. And he had pulled over in a parking lot in Vidor, Texas, by a police officer. And prior to the police officer coming up to the vehicle, he had a severe panic attack, thinking that he was going to be attacked as well. And he took off, and he understands that what he did was wrong and that there were multiple units from different counties involved that gave chase on, for quite some time. However, when the chase ended and Mr. Mendoza stopped the vehicle, he bashed out the window on the driver's side, stuck his hands out, to show the officers that he was unarmed and that he was complying. He listened to officers' commands. He did get out of the vehicle. He walked backwards as instructed, slowly as instructed, with his hands in the air as instructed. And then he was pushed down aggressively after they made contact. Now, in the precinct's investigation report, Melanie Ramirez recommended that, well, noted that Mr. Mendoza was taking full responsibility for this offense and that he expressed remorse for his actions. And she also pointed out that although he does have prior felony convictions between 2017 and the present offense, there was an absence of any new felony offenses, which shows that he does have the capacity for stability. And she also recommended that Mr. Mendoza be supervised on the mental health initiative caseload and continue mental health treatment, remain medication compliant, which is one of his challenges that he faced. And a lot of that was due to him not being able to receive or handle the medications that he was prescribed. I understand that now, I believe he is taking Wellbutrin.
Yes, ma'am.
And also Cyprexa. And those medications, as you can see, have completely transformed him. I mean, he's functioning. He's been able to be a law-abiding prisoner. There haven't been any altercations at the jail. There haven't been any incidents reported. And he's been in custody for a long period of time. And for these reasons, I believe that he would be a good and successful candidate for probation. And so I would also like to call Mr. Mendoza, and he would like to say a few words to the court. Mr. Mendoza, what would you like for the court to know?
I would just like everybody to know that I apologize for what I've done. I'm deeply sorry. I did not mean to run.
What did you mean to do?
I was pulling over and the schizophrenia was telling me, just like an audible voice in my head, that they were going to hurt me, and I drove off.
Mr. Mendoza, let me ask you something. When you say you hear voices, because that is also mentioned in your medical records, what kind of voices are these that you hear?
Sometimes I hear my friends from Lubbock, telling me to hit myself. That's what the Zoloft and the Vraylar were causing me to do, with myself.
And is that what the sertraline was?
Yes, ma'am.
Okay. These voices, how long have you been hearing these voices?
Since after my sister passed away.
And are these voices ever positive?
No.
They're negative, right?
Yes, ma'am.
And what kind of things do these voices tell you to do?
To hit myself.
And to injure yourself.
To hurt myself.
Okay. And what are your intentions if you were placed on probation in terms of residency? Where would you be residing?
Either at the Beaumont Center, the Texas, or the Franklin Land Manor, or with my friend Susan, who's been helping me. I've been working on her house since Hurricane Harvey.
Okay.
And she's been needing work on her house.
Okay. Do you have family that's willing to step in and help you
Hold
as
on.
well?
How long have you been in jail?
A year and 7 months.
Okay. When was the last time you worked on the lady's house? Before you went into jail?
Yes, sir.
Okay, that was over a year and a half ago.
Yes, sir.
Okay,
Okay, yes, sir.
Yeah, I thought he was, the way he was speaking, I thought he was at night working at
Right,
the house or something.
right. Like a furlough or something.
Didn't understand that.
Mr. Mendoza, with regards to your medication, that in your medical records, that's been a concern for them, you know, that you weren't making all of your scheduled appointments. Your medication was kind of irregular. So what are your plans if you're placed on probation with regards to ensuring, like what kind of support do you have to ensure that you will make your appointments, take your medication regularly? What are your plans for that?
Well, the good thing about being in Beaumont is everything is within walking distance. And I definitely intend to go to all of my appointments, take the medications that are prescribed to me, the ones that I'm on now, hopefully. And then,
And you have 2 children.
yes, I'd like to get home to.
And what are their names and how old are they? And you don't have to say last names, just first name.
Melody, she's 17, and Caden is 17. He's 16, about to be 17.
And prior to this incident, did you have a relationship with your children?
Just over the phone.
And do you plan on being more active in
Yes.
their lives?
Yes.
Physically?
Yes, I'd like to go to the Texas Workforce Commission and go straight into welding.
Okay.
Do that.
Let's talk about your certifications and what your work capabilities are. Do you have any certifications? Or did you have any certifications or any knowledge or skills that would
Yes.
help you?
I'm a master tile setter by trade. I've been doing that since 2003. And I work on houses, anything remodeling,
So carpentry.
carpentry, plumbing, some electrical work, but mostly tile work.
So jack of all trades.
Yes, we have.
Okay. Your Honor, at this point, I would pass the witness.
Your lawyer represented that you've not been in trouble since you've been in custody. Truth is, you've had 4 different incidents filed on you through the jail, is that correct?
Not that, I just know one.
Which one are you admitting to?
They said that I wasn't compliant. I think I stayed awake to read a book at night, and then I guess they want you to be laying down reading.
And that was back on January 9th of 2025, but you actually had write-ups for not following rules in March 2nd of 2025, November 13th of 2025, as well as November 16th of 2025.
So,
Isn't that correct?
I don't know. I've never received any of the yellow pages that they usually give back for a case.
you're stating you were disciplined in the jail for reading a book? You were reading a book?
That's what.
There's certain times you're not allowed to read a book?
Yes, sir. Again.
All his reports are about rules, Judge.
Okay. Was it at nighttime when people were sleeping?
Yes.
Is that it? Is there a rule at the jail that states that you sleep time is for everybody to sleep, and if you're reading a book that might disturb others? Is that
basically
what it is?
Sir.
Okay.
All right. So you only remember one of those particular matters, correct?
Yes, sir.
All right. So let's shift gears. Your lawyers presented to the court that all these issues are dealing with your mental health. We all know, because the judge is reading your PSI, that you've been in the criminal system on multiple occasions. Did you bring these allegations to the forefront in any other time that you've been dealing with the court system, sir?
The times that I've been in trouble, I've just sat whatever they had out.
So you've never made this statement before?
No, sir.
And in fact, you've gone through pretty much everything that our system has to help somebody with drug problems. You actually have a pretty serious drug problem, don't you?
Yes, I do.
You've actually gone through safety in 2020. You went through ISF in 2022. You went through a program that Lubbock had called Managed Care back in 2002 to 2005.
Yes.
As well as Teen Challenge all the way back in 2003 for a 5-month period.
Yes, sir.
But yet on this particular occasion, you were in possession of methamphetamine in 0.5 grams. That's the other crime that you were charged with. You remember that?
Yes.
Were you actually under the influence of that at the time?
No, sir. I had the drugs on me, but I wasn't under the influence. It was 4 a.m. I was sleeping in my truck in Susan's driveway, and I woke up to hearing voices about my friend being assaulted at her house, and I drove to Vidor, and that's what happened.
So your lawyer also highlighted how well you followed all the officers' instructions at the time that you were arrested. You didn't make any type of statements at that time at all about the matters that we've been discussing so far in the sentencing hearing, correct?
Well, I just pleaded with them to not hurt me. That's the only thing
So let's be specific. You did not say to anybody that was wearing a police officer's uniform that you were concerned about your friend that was being sexually assaulted.
No, I never had a chance to.
That doesn't appear anywhere in the records until you did this PSI, correct?
Yes, sir.
Any other questions I have, Judge?
I want to just clarify a few things here. Your criminal history, let's just talk about felonies. There are some misdemeanors, DWI second. So you had a DWI first, a DWI second, according to the indictment, the second paragraph that was not pleaded true to, but it was alleged in the indictment that you were convicted of a 3rd degree DWI on or about November 8th, 2012. And that looks like it's relevant. It's in the pre-sentence report. By the way, any objections to the pre-sentence report other than what's been stated?
No, Your Honor.
Because it's made a part of the record for this hearing. This states in 2012, you were sentenced to 3 years imprisonment for a DWI 3rd. So you had 2 priors, and then you had been placed on deferred or unadjudicated probation for illegal possession of a controlled substance in 2010, and that was deferred. Then you had the DWI 3rd conviction in 2012. Then in 2016, 70 days in jail, illegal possession of a controlled substance. That must have been reduced to a misdemeanor. Is that right? Because that doesn't look like a felony punishment. I don't know.
Unless it was state jail.
What had happened was
state jail.
They didn't have any evidence.
It says you spent 70 days in jail for no evidence.
It was as a 1244, Judge.
Oh.
You're going to be straight with me. You're under oath.
Yes, sir.
Nobody knows more about your life than you. He's correcting you about your life.
There was a time that had happened where I did 6 months, and then my lawyer said that it was dismissed.
Let me say this. That's not
This is the 70 days. Yes, sir.
Is that the one we're talking?
Okay, I'm looking at this state jail felony, 70 days. Then the judgment of conviction by the court, state jail felony. It was 1244, section 1244 of the Texas Penal Code, which means it was punished as though it were a misdemeanor.
Yes, I think he's.
But it's a felony.
Yes, I think the dismissal is what.
I know you're doing your best you can to explain it, but that's not the way he said it. And nobody, you and I, he knows more about his life than we do. But be careful. You're under oath here.
Yes, sir. Yes, sir.
So we're going to go through this. So that's a second felony, this controlled substance. Then we've got in 2017 attempt to take a weapon from an officer, and that was 225 days in jail. Was that another 1244?
It was.
It was. So that's a third felony conviction. Not counting the 2017 10 years conviction. So this is. Yeah, another 1244 conviction. You were punished as though it were for misdemeanor punishment, but you were convicted for a felony at state jail felony. So that's 4. So you got 4 felony convictions. And here you are with me. Yeah, okay. Yeah. So and this earlier illegal possession of a controlled substance out of Hale County, Texas, did you complete that probation without being revoked? In 2010? Yeah. Did you complete that or was that revoked? It doesn't show.
I ended up doing 2 years state jail for that. When I got this down there.
Okay.
Okay. So that's a 5th conviction, right? 5. This. So. Criminal history and the circumstances of a crime are all the basis of what punishment shall be. That's the theory of punishment, using those basic parts into the formula. So here in this event of evading arrest or detention, the police arrest you and you're acting bizarre. And they've got this crystal methamphetamine on you. You don't think that has something to do with that?
I didn't run because of the drugs, sir.
Okay. Where'd you get those drugs from?
Giving a ride to
No,
someone.
who did you get them from, sir?
From somebody, homeless person.
A homeless person, unnamed homeless person who's just giving out crystal meth to people?
I was giving a ride.
Every polygraph in this town is ringing right now. It's so unbelievable. This isn't believable.
I was going to some other place, sir.
No, I'll tell you where you're going. You're heading to prison here. You're not being truthful. Of course, crystal meth makes people act goofy.
Yes, sir.
You've got it on you, but it's something else. And you can't even tell us who you get it from. That's how forthright you are at the time of sentencing. You got 5 prior convictions and you're asking for mercy? Okay. Final, let's move forward here.
Yes, sir.
From the defense, what are you asking for and what the state's asking?
Probation, Your Honor, that the court would be so kind and merciful.
Judge, I'm gonna
Given something, you're doing the best, she's doing the best she can, but she's trying to
Your Honor, I would point,
making something out of nothing here. You got to give her something to work with.
Your Honor, I would point out that, and it's no excuse, absolutely, it's no excuse. But it is very common for persons involved or dealing with mental issues such as schizophrenia, post-traumatic stress disorder.
When was
You know, that
when
they
was he ever-
medicate, they
when was he ever
self-medicate.
diagnosed with that?
When?
When was he just diagnosed with that? Yeah.
So in the very beginning, well, 2023 was the schizoaffective disorder. It was official. That was the first note that I have in the medical records when he started receiving services. The
But he
major
was, where was he
depressive.
at that time? In jail? Wasn't he?
And, no, Your Honor.
No? Were you?
He was on parole. He was on parole. He's set to finish in February 2027. Is that correct? But it's very common, Your Honor, for people that suffer from mental diseases, because they are diseases of the brain, that they self-medicate. And
And when were you diagnosed with that?
An excuse, but
2023.
Okay.
he was
All right.
also diagnosed.
Hold on with that. Hold on with
Okay.
that thought. We're gonna go to the
Okay.
pre-sentence report. And I want everybody to look at page 4. Substance abuse history. Cocaine. Age at first usage, 19. Date of last use, 2006. Frequency, daily. 6 years of daily cocaine use, and it's some other psychological problem that's affecting him, not daily for 6 years cocaine use, plus throwing in the crystal meth that we've got him on. And that's some kind of other basis of his psychological problem.
Your Honor,
You can't be on daily cocaine use for 6 years and not have some kind of psychological adverse effect.
Your Honor, in 2001, he was also diagnosed with major, and this is in 2001, major depressive disorder and bipolar 2. And that was all the way back in 2001.
Yeah, but that's when he was using cocaine every day.
I know, Your Honor. And again, like I said, I'm not making an excuse.
Where were you getting that every day? How do you get that every day? You can't, how can you afford that for years? Where were you getting that from?
I was working, sir.
No, that's not the answer. Where were you getting that new drugs from?
From a drug dealer.
I'm sorry?
From a drug dealer.
The unnamed drug dealer, the quotes around the unnamed drug dealer. The same guy for 6 years? Or lady? I don't know.
Yes, sir.
6 years. Where were you getting the money from for that?
I worked.
You made the choice every day for 6 years.
Sir.
You know how many days that is? 365 per year for 6? 2,000 days in a row? You couldn't figure out the right choice to make?
It's been a struggle, sir.
Your choices are your struggle, your own choices. You know right from wrong, right? Okay, and then we're not even talking about the crystal meth that you get caught with at the scene of the crime here. Okay, all right. Look, this is years and years of consistent wrong choice making that we all as adults know better. And we pay the consequence when we made the choice. You're asking, the defense is asking for probation. What state saying?
15 years is what's warranted, Judge.
All right,
When we look at, I'd like to point out that factually, this man ran from Vidor all the way through on I-10, all the way through the heart of Beaumont till the very end, where he didn't stop. The law enforcement had to use means to disable his vehicle. We're lucky no one died in all this, and those are facts out of this particular offense. This plea came after 2 years of it sitting around with him exercising the right for trial, which is absolutely fine. But part of the preparation of getting ready for trial was the reviewing of all the media that takes place. And there was no indication this man was under some mental health breakdown from my perspective. If there was evidence of that, I would have had concerns about that going forward in the jury trial, which is why I highlighted that nothing was said to these law enforcement officers. Nothing was said until we get down to let's see what's going to happen with punishment. This man was using drugs admittedly in this PSI up until the time that he was arrested. The only thing he didn't admit to was the cocaine that you talked with him about. We have done everything we can to help this man with this system before he got here. And it's failed. It's failed miserably. And that is why I'm strongly opposed to the concept of giving him another break. He's already gotten 2 state jails that were dropped down to county jail time. Probation to me is a joke. I appreciate the advocacy, but it's not warranted here. What the PSI officer does properly point out underneath the quote unquote recommendations, the last sentence, first paragraph. Given the combination of these factors, the defendant appears to require a high level of structure, accountability, and treatment-focused supervision to address the criminogenic needs identified during this investigation. We don't see those words very often, Judge, and you and I have read a lot of these PSIs. That tells me that in the most kindest words they can say is that probation is not appropriate for him. She then goes on to explain the reason for that is because of his his repeated justice involvement, persistent substance use concerns, and she also details his mental instability. They're using it as a crutch today. I don't see anything that warrants some mercy here. Even the comment that the officers were aggressive about how they took him down, that's inappropriate. These officers did everything they could to keep the citizens of Jefferson County safe. I'm trying to follow that through and asking Your Honor to sentence him to 15 years TDC.
Anything else? Okay. All right, Mr. Mendoza, anything else you want to add, sir, here? In this 24 CR 1769, the court finds as follows, that the defendant has pleaded guilty to paragraph 1 and true to paragraph 2 of this indictment. Paragraph 1 alleging the 3rd degree felony of evading arrest or detention with a motor vehicle, and paragraph 3, a prior conviction of illegal possession of a controlled substance with intent to deliver a 1st degree felony. So this 3rd degree felony has been enhanced to a 2nd degree felony. The court would note, though, that there is a paragraph 2 of felony offense alleged that was not pleaded true to, and that your attorney was able to negate that from this disposition of a punishment range if you would have been pleading true or found true of paragraphs for paragraphs 1, 2, and 3, you would be facing at least 25 years to life imprisonment. And that's why she's good at what she does. She does her best to minimize the exposure. At the end of the day, the facts of this case, even somebody well-versed and spoken like her, has to face the facts of this case. And the pre-sentence report is made a part of the record without objection. And this pre-sentence report states that you, before you committed this offense, had 5 convictions, felony convictions, and that the circumstances of this case included being in possession of crystal methamphetamine. You have drugs, which are a choice that we make, illegal abuse of drugs. You had 5 or 6 solid years of daily cocaine use in your history that had a lot to do with this event, but at the time, you were not using daily cocaine like that block of time, but there you are with the crystal methamphetamine. Back to it. You knew it was directly from the devil, and it had hellish consequences for you in the past. You went back to it. You visited the devil again. That's your choice. And when you dance with the devil, you pay the price. Just wish you would have learned a lesson back then that it leads to destruction, including your freedom. These are terrible. And once again, the fact that you're not looking at a minimum 25 years is again a tribute to the vigorous defense that you have here when you're lawyering. There is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of evading arrest or detention with a motor vehicle enhanced to a second-degree felony punishment. I'm following this agreement, though. And this is a cap of 15 years, no less than 2, no more than 15 years confinement in prison or regular probation would be allowed if I sentenced you to 10 years or less. Your criminal history and the circumstances of this offense show that you have continued to make poor choices. You have to do better, because the next event, you're looking at 25 to life again, and it would be hard for a subsequent disposition to be less than 25 years after you've already been given a reduction from what you were exposed to as a cap of 15 years in prison. I hereby find you guilty beyond a reasonable doubt in this crime, and I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 15 years. You will be given credit for all time you have served in accordance with this case. You understand what has happened today, sir?
Yes, Your Honor.
Do better. These are your choices. So make better choices.
No.
This is 25 to life every time you commit a felony from here on. Okay. That is all.
Okay. Ms. Alexander, can you come on the Zoom call, please? What this is on for review?
Yes, it is, Your Honor. And the issue was that in her original assessment, the
Okay, so hang on just a second. Hey, just stop for a minute. Ms. Grisco, can you move to the side, please? Hi there. So if you need to talk, I'm going to have you guys step outside. And so it's a little disruptive.
I'm so sorry.
That's all right.
Proper decorum, yes, sir.
Okay.
Let's go outside.
What's your name, ma'am?
Her name is Samantha Schuler.
Okay, thank you. Okay, nope, I just want, just asking your name. And so you can step outside and then,
She just said I don't need to come back in. Is that true?
Well-
I just said that I'm not her attorney, so let me. Yeah, I know
so,
you're
so
not.
hang on, just, ma'am,
I'm sorry. No, yes, sir.
let me
Yes, sir.
figure things out for you.
Yes, sir. I don't even see my attorney in here,
Okay, well,
but I want to go anyway.
Your Honor, if that's Ms. Schuler, that's my client.
okay.
Oh, Aaron,
Okay,
hi.
so
honey.
ma'am.
Yeah.
Okay, so ma'am, don't go. Don't go.
Okay. what
No,
do I
no,
do?
I didn't tell you that. And
You said to process them outside.
no,
service
I
sector.
said, when, after that attorney left,
Yes,
when
sir.
now that we'd have your attorney is here,
Yes, sir.
I just want to get on everybody on the same page.
Absolutely.
Mr. Swinson, do you need to speak with her?
No, he does not. I speak for him.
Okay,
He
so
does not speak for me.
ma'am,
Then he's fired and he can be a
Okay.
consult. Let me speak
Okay.
for myself. That is my
Okay.
right. Respectfully, sir, no one can advocate better than me.
okay,
Please, I haven't even spoken to him since I was in jail. I did that on purpose. So Aaron, you are more than welcome to stay on the call or you're fired. I got 5 different attorneys in 5 different other counties. I've covered 6 in 32 days. I'm not playing with my life. I will demand to be heard respectfully with your proper decorum, with no interruptions in your courtroom. This is my home. Your reservation. I'm gonna cry Priya. I'm gonna tell you that your prosecuting attorney respectfully is an idiot. My mother, Shirley
ma'am,
Jackson, well,
okay, so,
how much do you want? This is ridiculous and a waste of your time and mine, but I'm here. I
Okay.
didn't know he would be here. I was
So,
gonna go forward
can you-
anyway.
Can you listen to me for a
Yes,
moment, ma'am? Okay, thank you. First of all, I was in the middle of a hearing.
I'm so sorry. She asked
And
me
then, okay,
questions.
can you just listen to me, please, ma'am? Okay, I was in the middle of a hearing. I'm going to finish that hearing, and then you can take a seat there, and then we'll take up your case, okay?
Yes, sir.
Okay, thank you. You can go ahead and grab a seat there. We'll call you back up here in a couple of minutes. And then, Mr. Swenson, I'll have you stay on the Zoom call, at least be present. And then Ms. Langley, we were in the middle of speaking with Ms. Alexander.
Thank you, Your Honor.
So Ms. Schuler, you can come on up and take a seat there at the table.
I don't know, Your Honor, is Aaron still there? I don't know.
Yes, yes.
Perfect. Aaron, are you fired?
Okay, so ma'am, listen. I'm gonna set some ground rules
Yes,
here,
sir.
okay? All right?
Decorum, I love
And so,
it.
yeah, and so the other thing is here too, and I don't want, you know, you used a pejorative or insulting term towards other people in the courtroom. And
Then
so
they need to do their jobs.
I don't
shouldn't
think that
tell
that's,
them
okay, so,
respectfully.
and another thing I would like is if you would, you know, not interrupt me or at least hear me out when I'm speaking.
Yes, sir. You
Okay.
would deserve that. This is your house.
Thank
I'm
you.
so sorry.
Well, it's not my house.
It
but
is.
we're in-
It's your courtroom.
Okay, we're in courtroom.
You deserve respect and proper decorum from me. Double standards do not apply. I cannot expect you to do one thing and me not do it myself. I understand the assignment, sir. Can we continue? I hear you loud and clear. I'm not trying to leave in cuffs, although I am prepared to do just that. So
No, there's no reason for that I can tell.
there wasn't a reason in the first place. It's not simple assault, sir. It is assault and battery for me. I want Travis arrested. I want her arrested. She won't survive Nisqually. I want her in mental health. He is a felon. There's
Ms.
a gun
Schuler.
in that house.
Ma'am.
I would advise you not to speak
No,
about the case.
Okay, so
Okay,
Mr.
he's done.
Swenson, just
Mute
a
him.
second.
I don't want him.
So,
Get him gone.
Okay.
It's my right. Get him gone. Aaron, no. You're documenting all of this, right? Thank God. How do I get the transcript? I can't wait. Can I, Your Honor, am I able to, no, because you guys need time to do it. It takes time to process, takes time for medical records requests. So for the record, I would like the public records request for all sheriffs, everything, the arresting officer, his partner, my mother. Should I give you away the golden ticket and let you know why you're wasting
Okay.
your time?
Can you let me speak for a
Yes,
second?
sir.
Okay. So first of all, there's a few things. I guess I'll start
There should be two.
where you ended there.
Yeah.
And that is all those things about public records requests,
Mhm.
that doesn't come to me, that
How do I get
doesn't
the
come to the
transcript?
court.
I can
Or
ask
that
her.
doesn't,
Remind, I got it. Yep.
or anything like that.
I'm all over
If
the
you want a
place.
transcript of of what's happening here, you can certainly order a recording. You can get that. This is all being recorded. It's all
Yeah.
public records.
I
You're
can't
entitled
record
to all
because
of
it
that.
is a federal crime.
And so, ma'am, what,
I am not well. I am hurt.
okay, so,
But my mind is my most powerful tool, and I need to proceed with or without Aaron, and I need you to sort of. My grandfather, Oscar Schuler, was the chief of detectives for Homicide Division. He has a placard at the Capitol. I am somebody. He's nothing to me. He can stay or go. He can listen. I don't care for
Okay.
grab the popcorn,
so
sir.
I think that what I would like you to concentrate on is,
Actually,
is
I
what-
want a continuance.
what you're being charged with.
September 28th. I will be available after September 20th because I have another ridiculous criminal trespass in Olympia on a house that I was going
Right.
to buy. They didn't even call.
Well, I would like to,
This is a very simple case, but I'm going to make it complex on purpose. I am available after September 28th.
so hang on just a minute. Before we do that, I want to get to you've made some comments about Mr. Swenson as your attorney and all
Or
that.
Priya, how about criminal rape on Nisqually Reds? How about the fact that I haven't been able to get to a hospital because nowhere is safe? Because when you cry Priya,
Okay,
prisoner rape, what is it, established association? Nobody knows this word. Why? I said it on an open channel. Guess how they found me? Criminal trespass. There's not even an address on the order. You know that. The prosecuting attorney said, "Why are we here, Judge? I don't understand what the prosecuting attorney wants me to do. Your prosecuting attorney here in Lacey did not ask the right questions. I'm going to get him disbarred, or he's going to listen."
okay.
Aaron, you hear me? Yeah, I know you do. Say less, do more. And I'm right. Dude, I'm right.
And that, ladies and gentlemen, is where That is where the live stream cut. That's where the judge sent the little hand signal that we're going off the air for this one. Yeah. Every so often you will see it go down in in Thurston County, where things get so crazy, things get so harsh so quickly that they just kill the stream. It went offline for about 10 or 15 minutes and came back online, and she was nowhere to be seen. I looked, I listened, I watched. They did something with her. I don't know if the bailiffs came in and took her out for a meeting with the nice guys in the white coats. I'm not sure. We've seen those things go a lot of ways, but that's how it ended when we were watching it live, and that's how it ends tonight. Until tomorrow, ladies and gentlemen, I am your lone wolf Fuso. We're done here, but we're not done. We're going to hang out with Hut. So hang out 1 second, and while you're here, while I have you prisoner, I do want to say a great big thank you to Renee Galloway, who came by for, it seems, her first stream tonight and dropped a big super chat. Thank you so very much for coming by tonight, Renee Galloway. Thank you so much, CE, Specs, Northwestern, all you crazy people. Steven, you donators, good night. Steven, good night. Did I get the heart on that one? I got the heart on that one. Yeah, cool. Oh, I'm also supposed to do this thing, aren't I? This is how that works. Yeah. There, Renee Galloway, Steven, the objection. Thank you so much, Kara, Rhonda, Specs, Becky, Mama, Wolfie. Rhonda, thank you so much. Spam that address where we're going. I'm not going to bother trying to pin it, not at this late date. We are redirecting directly over to Hut. Stand by. And if you want more content from this old gray wolf, I find a lot of good content, come on by here every single night of the week, 8 p.m. Central, 9 p.m. Eastern. And on Saturdays at 11 a.m. Central Time, noon Eastern. We'll have a lot of stuff just like more cases, more cautionary, more interesting stuff, in my humble opinion. And more than anything, more wonderful chat. Chat's been amazing tonight, ladies and gentlemen. We concluded that the best MTV Unplugs of all time are, in fact, Alice in Chains and Nirvana. If you disagree, you can tell us in the comments all about it. That's for sure. But for now, I am your lone wolf Usul, and I am, in fact, hope. And remember, only you can take a bite out of crime. Bye!